The Committee on Finance is hereby called to order. The time is 10:05 on Monday, December 13th, 2021. Pursuant to applicable law and my determination that attendance by remote means is necessary because an in-person meeting is not practical or prudent due to the declared public health disaster caused by COVID-19, this meeting is conducted by video conference. For questions during the meeting, aldermen should use the raise your hand function to indicate they have a question. Members of the committee shall be given preference. If you wish to make a point of order, point of information, or point of clarification while one of your colleagues is speaking, please use the raise your hand function and unmute your microphone. We will now have a roll call to establish quorum, so please unmute your mic when your name is ready to be called. And please note that your yes or present response will be deemed a yes vote when a quorum call is used as a reference vote for later items. And then we will do the quorum call and then a roll call and then go to public speakers. So Chairman Wagasback is present. Vice Chairwoman Hairston.
Present.
Alderman Hopkins.
Present, Mr. Chairman.
Thank you. Alderwoman Dowell.
She's present.
I'm here. Here,
Okay.
Mr. Chairman.
I've got you. Thank you. Alderwoman King.
Present.
Alderman Sawyer. Alderman Mitchell. Alderwoman Harris. Alderman Beal. Alderwoman Sadlowski Garza.
Present.
Alderman Thompson.
Here.
You, yeah. Alderman Cardenas. Alderman Quinn.
Here.
Gotcha. Alderman Burke. Alderman Lopez. Alderman Moore. Alderman Curtis. Alderman O'Shea. Alderman Brookins. Alderwoman Tabares. I see you there.
Present.
Thank you. Alderman Scott. Alderman Burnett, I have. Alderman Irvin.
Alderman Irvin present.
Thank you. Alderman Taliaferro. Alderman Roboris. Alderwoman Austin. Good morning. Alderman Villegas.
Present.
Thanks. Alderwoman Mitz. Alderman Sposato.
Nick Sposato is present.
Thank you. Alderman Napolitano.
Present, Chairman.
You there? Thanks. Alderman Riley.
Present.
Thank you. Alderwoman Smith.
Present.
Alderman Tunney.
Present.
Alderman Osterman.
Present.
Alderwoman Silverstein.
Present.
Ladies and gentlemen, we have 20 members present at this time, and we have a quorum. We only have one public speaker today who has signed up for public comment, and that is Mr. George Blakemore. And then we will move on to the agenda after Mr. Blakemore. Mr. Blakemore, you have 3 minutes. Thank you.
Hello,
Yes, Mr. Blakemore, we can hear you.
I'm wondering how are you conducting your business today. I'm wanting to know about how many items that you have on your agenda, and I'm particularly concerned about the agenda that's dealing with internet. And I'm wanting. Yes, I'm listening.
Okay, Mr. Blakemore, we have 8 items on the agenda, and then we have 4 settlement items. And and Jeanette Young's settlement is on that agenda.
Yes, but are you going to let the speakers speak on each item? How are you running this meeting?
We're going to go ahead and have you speak on all of them at this time. We actually have a fairly short agenda, so if you want to speak on Miss
Yes, but
Young, go ahead.
how can a citizen, a concerned citizen of my stature, be able to speak on all 8 items? So what I'm going to do, I'm going to speak now, and perhaps if I go over the 3 minutes that you will allow me a few, because you are compelling me to speak on 8 items.
Well,
for 3
go ahead and
minutes. But
yeah,
right
go ahead
now,
and speak.
sir. Right
Yep.
now, I'm concerned about the black lady that was the police did something so egregious, went into her apartment and she was nude and naked. I've never heard of anything like happening like that to a white lady, and I just think it's unacceptable for you all to have her to jump through these hoops over 3 years ago when that happened, and then to try to force her to take a settlement, and now you all have kind of backed down and decided to do justice. So this has to stop. How the police are treating their black citizens. I'm not concerned with color or white, but black citizens. 95% of these settlements over billions of dollars from police abuse. And most of that abuse have been black men and black women and black children. Now, I challenge you all that's listening to Mr. Blakemore, the ancestor sent him. This must stop. Truly, Black lives must matter to all of you, every one of you. Black lives must matter. And I never, in my 50 years being a citizen, 52 years of being a citizen of Chicago, ever heard of a black policeman shooting or pulling his gun out and pointing it to a white. They won't do it because they got a code. White lives matter. Now I'm muting my damn self.
Thanks, Mr. Blakemore. It's
Goodbye.
giving you a few extra seconds there, but we appreciate your comments, and we'll see
Well,
you at the full city.
thank you. Perhaps if you can't answer those questions, it's why that never happened. Why that doo-doo?
Yes, thank you, Mr. Blakemore. That'll be answered in the discussion period during the settlements. Thank you.
Chairman, Alderman Mitchell.
All right, let me go back through there and pick up a couple people there. Alderman Mitchell, you'd be recognized for quorum.
Alderman Nugent is present.
Thank you, Alderman Nugent. And Alderman Vasquez. All right, as people come into the meeting, we'll recognize them for quorum. All right, ladies and gentlemen, moving on to the regular agenda. Item number 1 is an approval of the Rule 45 report from the November meeting. Does anyone have any changes or questions on that document? May I have a motion to approve the report?
Motion to approve made by Vice Chair Harrison.
Vice Chair Harrison makes a motion to approve the report by the affirmative vote of all members present for the roll call used to establish quorum. All in favor signify by saying aye.
Aye.
Aye. All those opposed? In the opinion of the chair, the ayes have it and the motion carries. Item number 2 is a communication recommending a proposed ordinance concerning the authority to amend the 35th and Halsted Tax Increment Financing Redevelopment Plan project and ordinance for conformity and compliance with Illinois state law, setting 35-year limits on retirement of obligations in the 11th Ward. For this item, we are joined by Tim Jeffries from the Department of Planning and Development, who will testify on the matter. Tim, are you ready?
I am. Good morning, Chairman Wagasback and members of the Finance Committee. For the record, my name is Tim Jeffries.
Deputy Commissioner in the Department of Planning and Development. I am here today to request the approval of an amendment to the 35th and Halsted Tax Increment Financing District. Specifically, this amendment would revise the termination date of the district for an additional 12 years. In November, the General Assembly authorized a 12-year extension of the district, but the city must also approve the amendment of the termination date before the district expires on December 31st of 2021. If approved, the new termination date would be extended to 2033. DPD anticipates that this district will additionally undertake a major amendment in 2022 to revise the redevelopment budget, update goals and objectives, and revise the land use plan to reflect current conditions. This action is, however, time sensitive and cannot be done concurrently with these other changes as is typical for the department. This action is relatively minor, and so that's it. So I thank you for consideration of this amendment, and I'm happy to answer any questions you might have.
Thanks, Tim. Are there any questions for Mr. Jeffries? 1 second, and I also have Alderman Thompson here, whose ward this resides in. Alderman Thompson, did you have any comments on this as well?
Yeah, thank you, Chair. I think Tim covered the more technical. I would ask for favorable support for this. This will allow us to continue to build on some of the momentum we've been able to do in our ward. We also are able to utilize funds from the TIF to help with our schools and parks, which we've spent our increment or our TIF monies on. So this will be significant for my ward and for the residents of my community. And I would ask for favorable support. Thanks.
Thanks, Alderman Austin. Give one last second here for anyone who has any questions, but I think that covered it. And I know we've been through this TIF a few times in the last couple of years, so I know it's an important.
Thank you,
issue.
Chairman. I just said that was an insult to Alderman Austin to call me Alderman Austin. She's much prettier than I. So
Thompson, sorry. Sorry, Alderman Austin. Boy.
I knew you meant Thompson, but.
Yes. Just because they rhyme doesn't mean I should miss it there. Sorry. So I'll take a motion from Alderman Austin to approve this item 02021-5284 by the affirmative vote of all members present for the roll call used to establish quorum. All in favor signify by saying aye.
Aye.
All those opposed? In the opinion of the chair, the ayes have it, and the motion carries. Thanks for having good humor this morning, Alderwoman. As always. All right, ladies and gentlemen, moving on to item number 3, the designation of municipal depositories is being held in committee to allow more time for public review of the ordinance language. I know we were moving pretty quickly on this, but Finance Department and Law wanted additional time to prepare the ordinance in the EDS forms for the legal issues to be covered. So we were going to hold this until January. It does not affect the existing municipal depositories, but we will have that ready to go in January. Item number 4 then is a communication recommending an independent auditor and a consortium of minority and women-owned accounting firms to perform the audit for the city of Chicago in the fiscal year ending December 31st, 2021. We're actually joined by several people for this item. We'll have Comptroller Sony, Jim McDonald from the law department, and then we have several people that were involved in the auditing team to take questions. And I think we'll start out with the Comptroller, Reshma Sony.
Thank you, Chairman Wagasback. Good morning, Chairman Wagasback, Vice Chairman Hairston, and members of the Finance Committee. Thank you for giving me the opportunity to address the committee regarding the appointment of the financial statement auditors. Every year, the financial statement auditors are appointed by the Finance Committee to conduct audits and issue opinions for 11 different reports, including the citywide annual comprehensive financial statements and the 4 enterprise-wide financial statements. But an official competitive procurement process had not been conducted for many years. Based on Mayor Lightfoot's commitment to conduct a formal competitive bid process, to ensure that we're receiving proper audit services, the Department of Finance issued the audit RFP on January 15th of this year on the DPS website and issued an ad in the local newspaper. To ensure that audit firms were aware of the RFP issuance, the Department of Finance directly contacted 65 audit firms, including 54 MBE WBE firms, to inform them that the RFP had been issued and that responses were due in late March. The RFP required 40% MBE WBE participation, and the contract is for 5 years with 2 one-year options of renewal. 4 firms responded to the RFP. An evaluation committee consisting of members from the Department of Finance, Treasurer's Office, and CFO's Office had been formed, and the committee narrowed down their selection to 2 firms, Deloitte and Baker Tilly. Oral presentations were given. The evaluation committee selected Deloitte as the auditor due to the following points. Deloitte was the only firm that provided an MBE WBE plan that exceeded the 40% requirement to be at 42%. Deloitte was the only firm to have 5 of the 11 reports signed and issued directly by MBE WBE audit firms and not by Deloitte. So these 5 reports would be issued on the letterhead of the minority or woman-owned firm, and they would be taking the responsibility in the issuance, with Deloitte providing backup and support services. The hourly rates for the MBE WBE auditors were the same as what Deloitte auditors are being charged. So there was a match in rates and there was no disparity in the rates. And there were competent key personnel that had experience with other government financial statement audits. We are requesting this committee to approve the appointment of Deloitte as the auditors for the city's financial statement audits. I'm happy to take any questions you may have.
Thank you, Comptroller. Do we have any questions for the Comptroller? I know we've had some briefings on this, but I want to make sure if you have any questions or concerns. I see a couple here, but let me just recognize Alderman Taliaferro for purposes of quorum. I think I missed him earlier. And we will start out with Alderwoman Austin.
Thank you, Mr. Chairman. I don't really have any questions. I just really have a comment. I want to say for Comptroller Sony, she's done an outstanding job on these auditors. I'm glad that she dived into it, not just allow it to just flow on its own, but she has stood behind it. So I'm really glad for that. At least we have a check and balance when it comes to her. So I'm sure that this auditors will do an excellent job because she'll be in behind them. But I didn't hear any of the ones that were African-American. Maybe you did say it, or maybe you had said it in our briefings, but I just didn't recall it.
No, actually, that's a really good point. And thank you so much, Alderman Austin, for your support and vote of confidence. So we have 8 firms altogether, but I think the key point here is that to your point, there's 5 out of the 11 opinions that are getting issued directly by our MBE WBE firms. And the 3 firms that are issuing this, 2 of the African-American firms that we have, which is Washington Pittman McKeever, and we also have Ragland and Associates, which their name is longer, as like Arnold, Ragland, Cannon, Morris and Associates, and then Prado and Renteria as well. So here what's happening is the treasurer's report, that is a required report that's being issued, is being issued by Arnold, Ragland, Buchanan, Morris and Associates. And then our audits, 2 audits that we have for the airport that are required by the FAA, and our Hilton hotel audit at the airport are being issued by Washington Pittman McKeever. And our required state audit for the library is being issued by Prado and Renteria.
Very good, very good. I couldn't tell what they were by the names because I think I was getting them all mixed up by name. But very good. Like I said, I know that you will stay in behind them as far as doing work in regards to the sister agencies and those that are working on the behalf of the citizens. So thank you for your efforts in regards to these auditors. Thank you, Mr. Chairman.
Thanks, Alderwoman. Alderman Lopez, would you like to be recognized for purposes of quorum?
Simply that, sir. Yes. Thank you, and good morning.
Good morning. And then I'll go to, well, I recognize Alderman Lopez for purposes of quorum, and then go to Alderman Irvin for comment.
Thank you, Mr. Chairman. Really quickly, I recall from last year's conversation that we were, I knew we were going out to bid for the audit, and we have the same auditor as before. Did any of the other Big Four accounting firms bid on the work or invited to bid on the work?
No, the ones that bid were BDO, Pro, Baker Tilly, and Deloitte.
And so, like Price Waterhouse, none of the other four majors bid on the job.
No, and we reached out to them to just find out, why. Some of the work that's being done currently, like let's say by KPMG, since they're doing internal work for us, they can't audit their own work, so that creates an issue there. Price Waterhouse and Ernst & Young are getting out of the government auditing business. They're more focusing on consulting. So if they bid it on the audit, then they wouldn't be able to do consulting work for us. And so I think that was just a business decision that they made.
Okay. And then also I see that you got some of these other firms signing off on work where in the past you haven't done that. Will they be supervised still by Deloitte, or will they be independently doing this work on their own?
Yeah, so this is a really good question. This year in the 2020 audit was the first year that we actually really implemented this full force. So the work was being done by the audit firm themselves, like Washington and McKeever were the ones who were running the meetings, doing the audit, the plan, audit engagement. Deloitte would be there on the back end, a lot for transition because they had the experience. But then also if there was any complex issues that were coming up, like we had some complex issues with our FAA reports that we had to do new reporting. So Deloitte provided some guidance there, but the actual running of the audit plan, talking to the partners was all dealing directly with the MBE WBE firm itself.
Okay, so we're actually in the room here. So if there's any like suit or anything, where does the liability lie in the case where we have Deloitte and another auditor working together?
So I think, if we're talking about liability in terms of let's say issuing a report and the report itself is not issued correctly, I mean, both the subcontractors and Deloitte themselves have responsibility, but Deloitte is the one that we are issuing the engagement letter with. So it would be Deloitte as sort of the overarching company, but the responsibility of the opinion itself lies with the company that's signing it. So like if it's Washington McKeever signing the opinion, they're responsible, like they would be for any audit, for that opinion that they issue.
Okay. We were concerned last time around about keeping the same auditor over an extended period of time, but it seems like we really don't have any other players in the market that really understand the complexity of the work that the city is doing. So I do understand the need to stay with Deloitte. I would like to see going forward an expanded role with some of our MBEs, which it seems like you're moving in that direction with an issue in the opinion. But I think that role could be further expanded and get those companies additional experience in that realm. I know some of those firms have merged with larger firms, and they could have the experience to do some of this complex work. But again, I do understand for SEC and other reporting purposes that we need one of those for accounting firms to be signing off on some of our major work. So thank you for your work on this, and I look forward to supporting you.
Thank you so much. And Alderman Irvin, you brought up a really good point. GFOA, our Government Finance Officers Association, which works in tandem, just like how SEC would work, has mentioned that because of the frequent lack of competition amongst audit firms, because our audits are so complex, making a policy of mandatory audit firm rotation would be counterproductive. And as long as we're auditing, if we have the same firm, as long as we're rotating the partner or director, then we're achieving that goal of making sure that there's a fresh perspective. So we actually have, in the last 2 years, gotten a new audit director who's signing off on our opinions, all of our opinions, and then having like the MBEs and WBEs looking at the reports and taking on the reports and signing on their own is also creating that fresh perspective. The other point that you brought up about we want to make sure that this is not just this plan, that we're actually thinking about how to grow this further. We've had conversations with Deloitte about that, and they're committed to be able to grow this out even further. So maybe it's not only 5 out of the 11 opinions, but we're seeing more opinions being issued where they can be, sort of our subject matter experts for complex things and be there for the support. But the opinions are getting issued and the work is being done by those audit firms. So they have both the backup as well as they're getting the additional exposure, I should say, to our audits.
All right. Thanks, Alderman. And Comptroller, just want to say thanks for your work on this. I know you put a lot of effort into it with your whole team down, at City Hall. And I also just want to recognize, ladies and gentlemen, that we have Bridget Flint, Maria Del Prado, and Lester McKeever here as well. They often show up to our meetings in person, and I want to recognize them for being here to answer any questions. So thank you, Comptroller. And before we make a motion on this, I want to recognize Alderman Burke for purposes of quorum. And Alderman Irvin makes a motion to approve item number 4 by the affirmative vote of all members present for the roll call used to establish quorum. All in favor signify by saying aye.
Aye.
Aye. And all those opposed? In the opinion of the chair, the ayes have it and the motion carries. Thank you, Comptroller. Appreciate your work on this.
Thank you so much for all your support. Thank you all. Take care.
And thanks, Alderman Burke. I have you for purposes of quorum.
Thank you.
Mr. Chairman,
Alderman Irvin.
Yeah, I apologize. I didn't realize that we had some of the other auditors on the line. So I wanted to recognize Mr. Caesar. That's someone that's been a legend in the accounting field in the city of Chicago from African American perspective. I did not want to disrespect such a great auditor and accountant in our profession. So I apologize for not.
No worries. I should have mentioned their names earlier when we first started, but I thought you could see them there. But I know that they show up to our meetings and they always answer questions when we need them. So they will be there in the future if they're doing the audits. Thanks, Alderman Irvin. And also I want to recognize Alderman Curtis for purposes of quorum. He is present, and let's see, that's it there. All right, ladies and gentlemen, moving on to item number 5. This is a communications from the Department of Law. Item number 5 is the monthly report of judgment, verdicts, and settlements from the Department of Law for the month of June. It will be placed on file with the clerk. Item number 6 is a proposed order for tag day permits on behalf of Children's International and Greenpeace. If there is no objection, this will be placed on the omnibus. Items 7 and 8 are authorizations for the payment of various small claims against the city and the denial of payment of various small claims against the city. If there is no objection, these items will be placed on the omnibus. All right, ladies and gentlemen, that concludes the regular agenda. We will now move to the supplemental agenda addendum where we have 4 items for vote today. These are Scott versus City of Chicago. Then we will move to Bell versus City of Chicago, Pedro Rios versus City of Chicago, and then Anjanette Young versus City of Chicago. And our first item is a proposed order authorizing the Corporation Council to enter into and execute a settlement in the case of Lawrence Scott versus City of Chicago for the amount of $625,000. Here to speak on this settlement from the Department of Law is Jeff Levine. Jeff, are you ready?
Yes, sir. Good morning. Thank you, Chairman and members of the committee. Jeff Levine, Deputy Corporation Counsel in the Law Department. This first settlement, Lawrence Scott versus City of Chicago, arises out of actions events that occurred on April 29th, 2014. Plaintiff Lawrence Scott was 23 years old at the time. On that date, at about 10:30 p.m., two CPD officers were on routine patrol near 931 West 53rd Street. It was a high crime, high drug area. In their vehicle, they approached a residence, which was the exact address where there had been a recent weapons recovery, and also an unsolved homicide had occurred in the same general area. As the officers pulled up to the residence, there was a group congregated there, and several of the people took off, including the plaintiff. One of the officers chased plaintiff on foot through several backyards and alleys, up to the point where plaintiff was approaching a metal fence. At that point, plaintiff took a small baggie of pot out of his pocket and threw it into a bush. That is not contested. Plaintiff then attempted to climb the metal fence. And at this point, the facts asserted differ between the city's account and the plaintiff's account. The officer asserted that plaintiff fell backward from the fence, and as the officer attempted to handcuff and subdue him, that the plaintiff resisted, struggling and kicking. The officer asserts that he administered 5 closed fist hand strikes to plaintiff's head in order to gain control. And after that, he was finally able to flip the plaintiff over and apply handcuffs. Plaintiff's assertions are quite different. He asserts that he was unable to climb the fence and instead turned to face the officer with his hands raised in a submissive position. He asserts that he momentarily turned his head to the side, and when he turned back to face the officer, he could see the butt of the officer's gun coming down, and that the officer hit him 2 to 3 times in the head with the butt of his service weapon. Plaintiff fell to the ground. When he regained himself, the officer was standing over him. He admits he tried to resist being handcuffed, but he was flipped over and handcuffed nonetheless. He was taken to a station for processing. He was arrested at 8:31 p.m. that evening. He was bleeding, although not profusely. And after 3 hours, he was taken to a hospital for treatment. The plaintiff claims that as a result of being hit in the head, he suffered and continues to suffer from ongoing injury. Specifically, at the time he had a concussion, he required 9 staples in his head. He claims post-traumatic stress syndrome, traumatic brain injury, nightmares, severe headaches, memory loss, impairment, mental speed deficits, as well as adverse personality changes. He has received medical treatment over the years, which lends credence to his claims that his brain injuries have permanence. The essence of this case is that the nature of plaintiff's injuries to his head, and this is confirmed by a Cook County medical examiner who was consulted by IPRA. And the Cook County medical examiner wrote a report which concluded that the lacerations to plaintiff's head, which again required several staples to close, were consistent with being struck by a hard object, a gun butt, as opposed to by a hand. Additionally, the officer suffered no injury. He showed no injuries to his hand after the event, which is difficult to square that with 3 lacerations requiring staples. IPRA, which is the predecessor agency to COPA, initiated an investigation here, and that investigation was inherited and continued by COPA, the current investigatory body. IPRA concluded that both officers had failed to adequately provide medical treatment, which resulted in a 1-day penalty. And COPA and then IPRA also concluded that the officer who hit plaintiff had used excessive force, which is consistent with plaintiff's assertion that he was struck by something other than a hand. That finding, which COPA has essentially adopted and is recommending, is a 15-day suspension that went through CPD review, which was approved, and that suspension is currently working its way through an appeal process. As Chairman Waguespack noted at the beginning, we are recommending a settlement of $625,000 in this case, which is down from an initial demand of $10 million. This is a federal court case, which means if plaintiff were to prevail, attorney's fees would be allowed, and we estimate that the attorney's fees alone, if plaintiff were to prevail, would be substantially in excess of $625,000. So we are recommending $625,000 as in the city's fiscal interest. I have with me my colleague Victoria Benson, who is also available to answer any questions, and I'll turn it back over to the chair.
Thanks, Jeff. Before we go to questions, I want to recognize as present for purposes of quorum, Alderman Beal, Alderman Cardenas, and Alderman Sawyer. And
Thank you, Chairman.
You're welcome. And let me just double check to make sure we have everybody here. Alderman Curtis, I had called you earlier. I just wanted to make sure you knew that I got you there.
Thanks a lot, Chairman.
All right. I have everyone there. So let's move on to questions, and we will start out with Alderman Sposato.
Thank you, Chairman. Hey, Jeff, were any body cams? Did the officers have their body cameras on?
Alderman, no, not in this situation.
Was this pre-body camera or was this?
I believe body cam was initiated a few years later. This took place in 2014.
Thank you, Jeff.
Thanks, Alderman Sposato. Do we have any other questions for Jeff on this item? Yes, Alderman Napolitano, and then Quinn.
Thank you, Chairman. Can you just please put me down as a no?
Yes, I'll do that. Alderman Quinn?
I'd like to be recorded as a no.
Alderman Riley?
I'd also like to be recorded as a no, Chairman.
Okay. All right, ladies and gentlemen, with the exception of the no's, let me run through that motion. May I have a motion to approve this item 1A? This is Lawrence Scott versus City of Chicago. By the affirmative vote of all members present for the roll call used to establish quorum, with the exception of Alderman Quinn, Napolitano, Riley. Anyone else?
Chairman. Alderman Curtis.
Yes, Alderman Burke.
Chairman, show me as a no also.
Thank you.
By the way, who
Yes.
are the plaintiffs' lawyers in this matter, Mr. Levine?
They are represented by Hatham Faraj and Matthew Amarin, who have offices on West Belmont.
Thank you.
All right. So Alderman Cardenas has a motion to approve this item by the affirmative vote of all members present for the roll call used to establish quorum, with the exception of Alderman, Alderman Quinn, Napolitano, Riley, Curtis, Burke. All in favor signify by saying aye. And all those opposed?
Aye.
Mentioned there. In the opinion of the chair, the ayes have it and the motion carries. Thanks, staff. All right, ladies and gentlemen, moving on to item 1B. This is a proposed order authorizing the Corporation Council to enter into and execute a settlement in the case of Frederick Bell versus City of Chicago for the amount of $330,000. Here to speak on this again is Jeff Levine from the Law Department.
Thank you, Chairman. This case also arises out of events in 2014. And this case has as its essence allegations of excessive force in conjunction with an arrest. On September 24th, 2014, 4 officers were patrolling near 7900 South Ingleside Avenue when they received word that a white Hummer in the vicinity was driving erratically, crossing over the center line and driving too slowly. Within a matter of a few minutes, they encountered the vehicle and saw that it was indeed driving in that manner. They pulled the vehicle over. One of the officers got out and asked the driver, who is the plaintiff, for his license and insurance, and he was unable to produce them. Plaintiff was then asked to exit the vehicle, but instead the vehicle lurched forward and stopped. It did not attempt to flee. It was just a sort of lurch and stop. He was ordered to put the car in park, which he did, and the officer reached in and removed the keys. The parties dispute what took place next. I will describe it, but first, simply for context, I would explain that the plaintiff, who he is now 62, he was at the time 55 years old. He was a retired executive with Unilever Foods, and he was a large man, approximately 6 feet 5 inches tall and weighing about 330 pounds. In any event, according to the officer's description of events, after the car keys were removed, the officer asked plaintiff to step out of the vehicle, which he did. The officer asked plaintiff to turn and be placed under arrest. As he attempted to handcuff him, the plaintiff screamed no, clenched his fists, and took an aggressive stance. Another officer tried to help gain control of plaintiff, but plaintiff began to flail his arms and attempt to walk away, with one officer hanging onto each of his arms. At that point, one of the officers performed an emergency takedown using what's called the leg sweep, essentially kicking plaintiff's legs out from under him. Plaintiff fell to his stomach, refused to give up his hands while continuing to kick at the officers. He then rolled from his stomach to his back with his fists clenched. At that point, one of the officers administered 2 to 3 knee strikes to plaintiff's shoulder in an attempt to subdue him. Because plaintiff was continuously moving, one of those knee strikes hit plaintiff in the head. After the knee strikes were delivered, they were able to free his hands and handcuff him. They then placed him in the back of the squad car, but were unable to close the door because he was leaning into it. To prevent him from hurting himself in the vehicle, they grabbed him and put him back on the ground. As a result of his erratic behavior, including his incoherent yelling, an ambulance was called. This was 22 minutes after the initial stop, and plaintiff was transported to Jackson Park Hospital. That's the officer's recount of events. According to plaintiff, and by the way, there was a passenger in plaintiff's car, and he was seated in the passenger seat during the entire time that plaintiff was being subdued. And at trial, he would testify in support of plaintiff's recitation of events, which is as follows: that as soon as the officer removed the car keys, he opened the car door, pulled plaintiff by the neck, onto the ground on his stomach, and they were having difficulty handcuffing him because of his size. Plaintiff asserts that because of this, they began to knee and kick him in the head, neck, and legs out of anger. Eventually, they were able to handcuff him and carry him to the squad car. Because of his size, they tried to lay him across the seat and kick his feet into the car. When that was not successful, they then began slamming the car door on his feet repeatedly. Once inside the squad car, plaintiff threw up. He claims that this caused increased anger on the part of the officers, and they pulled him out of the squad car by his feet, hitting his neck on the side of the police vehicle. Again, his version is corroborated by his passenger. Plaintiff passed out. He was unconscious for a day and a half, at which point he woke up in the hospital. I will describe plaintiff's hospitalization momentarily, but first I will note he was charged with resisting arrest, aggravated assault, and various traffic violations. After a bench trial in 2015, he was found guilty just of the traffic violation, but was found not guilty on all the other charges, including resisting arrest and aggravated assault. When plaintiff was first taken to Jackson Park Hospital, he showed symptoms of a seizure and/or a stroke. This included facial droop, slurred speech, confusion, and dizziness. While his CAT scan was negative, his EEG showed slowed wave activity, which can indicate a stroke, seizure, or traumatic injury. He also had bruising, scalp bruising, and lacerations to his head and arms. Because of the possibility that he had suffered from a stroke or a seizure, he was transferred to UIC, where he stayed for 12 days until October 8th. There, another CAT scan was completed, which showed that he had indeed suffered a stroke. While he was there, his condition generally improved, but he had 2 more episodes of slurred speech, left facial droop, and confusion, which could have been indicative of further mini strokes. He was then transferred to Christ Medical Center, where he remained for another 5 days. And following that, he was transferred to Provident Hospital, where he remained for another 11 days. Based on the medical evidence, we would suggest that it is likely that plaintiff was suffering from a stroke or other health emergency, which was the cause of his erratic driving and was the cause of his non-compliance with the officer's demands for him to submit to being handcuffed. Plaintiff will assert that he was not having any physical problem until he was pulled over and until he was kneed in the head, and that was the cause of his stroke. Regardless, plaintiff will assert that there was excessive force used here, and as I've noted, he would be a generally sympathetic witness at trial. We believe he has no criminal history. In any event, we are looking at an initial demand in this case of $625,000, and we are recommending a settlement of $330,000 in this case. This is also a federal case, which means, again, that if the case were to proceed to trial and plaintiff were to prevail, that attorney's fees would be included in this award. Chairman?
Thank you, Jeff, for that presentation. Let me start out with questions from Alderman Sposato.
Thank you, Chairman. Hey, Jeff, in the beginning, you said he was unable to produce identification. He refused to produce it, or he was unable to, or what was the deal? And then if his passenger knew was having issues, why wouldn't he step up and say he's maybe we think he's having a seizure or something like that. So what was the deal that he couldn't produce it, he wouldn't produce it?
Alderman, I don't know that fine distinction, whether he simply said I can't or I won't. As far as the passenger, I don't know whether he had a sense of whether the driver was suffering from a medical episode at the time. Vic, do you have any additional insight into either of those points?
Victoria, if you could just state your name first for the record, that would be helpful. Thanks.
Sure thing. Victoria Benson, Deputy Corporation Counsel with the Federal Civil Rights Litigation Division. As to the second question, based on the evidence thus far, the plaintiff's position is that he was not suffering a medical emergency at the time. Thus, there would be nothing for the passenger to have interfered with in the sense of, hey, he's going through a medical emergency. In terms of the first, I don't know specifically, but he was charged with a multitude of traffic offenses. The fact that he was ultimately not found guilty of not having a license or insurance makes me believe that he must have produced at the time of the criminal trial.
So at the time he was pulled over, we still don't know if he couldn't produce it or if he wouldn't produce it.
Correct. It was either one, though, either one would be something that plaintiff would assert, or that there would be an issue with the city needing to defend if he was having a medical episode that was the reason for his failure or unwillingness.
Okay. Thank you.
Thanks, Alderman Sposato. Vice Chair Hairston.
Thank you, Chair. What was the amount of his hospital bills?
Let me see if I have that in my notes. While I'm looking, Victoria, if you have that information.
Certainly. Victoria Benson again, Deputy with the FCRL Division. His medical bills totaled $138,463.05.
That's total with Jackson Park, UIC, Provident. There was one up there that I missed.
Correct. This is everything that the plaintiff submitted as his medical bills as a result of his treatment.
And rehab as well?
Yes, ma'am.
Okay. And is he still under doctor's care today?
We don't have any record that there's any permanent ongoing injury as a result.
Okay. And do we have any record of what has happened with those police officers?
There was an investigation done, and the conclusion was that there was no wrongdoing on the part of the officers.
So if I get pulled over and get beat by a cop, as we are often before this body monthly, and the officers did nothing wrong, and the investigation was done by COPA or by whom?
My records show that the ultimate conclusion was from COPA, since this event took place in 2014. I expect it's likely that the investigation was begun by IPRA and then continued by COPA.
And therein lies the problem. Thank you.
Yes, Alderman, I would note that I appreciate the points you're making. I take your points. The issue here is a concern that at trial, the plaintiff, in light of the medical, the fact that the medical record shows that he had a stroke, would enable him to assert either that the stroke was caused by being kneed in the head, or that the police failed to pay the appropriate standard of care to somebody who was having a medical event.
Thank you. Thank you, Mr. Chair.
Thank you, Vice Chair. Alderwoman Harris. First, let me recognize you.
I just wanted to be recognized for the quorum call.
Thank you. And Alderman Michael Scott Jr.
Yep, I'm here. Can you do that for me as well?
Yes.
Thank you, sir.
Let me just double check, make sure I got everybody. Okay. So I recognize Alderman Scott and Alderwoman Harris for purposes of quorum. And are there any other questions for Jeff on this item? Okay. So Alderwoman Harris makes a motion to approve this item by the affirmative vote of all members present for the roll call used to establish quorum. All those in favor signify by saying aye.
Aye.
Aye. Anyone opposed? In the opinion of the chair, the ayes have it and the motion carries. Thank you, everyone. All right. We'll now move
Excuse
on.
me, Chairman.
Yes.
Could you let Alderman Mitz in and record her present for the quorum? She's right here.
Yes, I will.
Thank you, Alderman. Chairman Scott.
So I recognize Alderwoman Mitz for purposes of quorum. Thank you.
Thank you.
And I've got you there. Let me just double check again. All right. Jeff, ready for number 3?
Yes, sir.
Item 1C is a proposed order authorizing the Corporation Council to enter into and execute a settlement in the case of Pedro Rios versus City of Chicago for the amount of $1.2 million. Here to speak on this is Jeff Levine from the Department of Law.
Thank you. Again, a case arising out of events in 2014. This is a particularly unfortunate one. This case arises out of the fatal shooting of Pedro Rios Jr., who was 14 years old at the time. This case is being brought by his father as the representative of his estate. The events began on July 4th, 2014 at about 9 p.m. The youth was walking through residential areas in the Portage Park, Old Irving Park neighborhood at about 9 p.m., as I indicated. He was 111 pounds, and he was later found to have a blood alcohol level of about 0.072, which would be consistent with about 2 to 3 drinks for somebody of his weight. He had run away from his parents' home about 2 weeks earlier, and his father had at the time advised the police that he had been hanging around with La Raza gang members. He stepped into traffic to cross Cicero Avenue at the intersection of Cicero and Bernice and walked right in front of the officers' marked police SUV. They needed to suddenly brake to avoid striking him. As he crossed in front of the officer's vehicle, they could see that he appeared to have something that he was holding at his side that looked to them like a gun. He did have a gun. It was a .44 Magnum. They stepped out, asked him to stop. He instead began running. One of the officers got out of the SUV and chased after him on foot down Bernice and into an alley, while the other officer pursued in the SUV. The chasing officer testified that as he was pursuing the youth turned and pointed his gun at him twice during the pursuit, and this prompted him to fire 3 shots at the youth. 2 of those shots struck the youth, who fell to the ground, dropped his gun, but immediately got up and continued running. The officer paused momentarily to pick up the gun and kept chasing. Shortly thereafter, the police SUV pulled up and blocked the youth's path. He collided with the SUV and fell down, but then got up again, turned around, and ran back towards the officer who was pursuing him on foot, ran right at him and tackled him, at which point they both fell down to the ground. The officer got up, and at that point, in the next few seconds, the youth died. The officer made a sweeping motion with his foot, which he asserts was done to clear the area of any guns, because at the time he had been holding both his gun and the youth's gun, and when the youth tackled him, they both fell. So he swept with his foot to clear any gun away, as well as to block the youth's path if he were to get up and continue trying to flee. However, plaintiff will assert in this case that it was not a foot sweep, but rather that the officer kicked a dying boy out of malice. There was video in the SUV, but it is not indicative of anything because it was filming on a parallel course to the youth's running, so it doesn't capture anything. There was no police body cam at the time. The events took place in the near the exterior of a security company, and so there is footage, stationary footage from security cameras that were mounted outside that business. They do not capture the point at which the officer asserts that the youth turned around and pointed his weapon at the officer. That was that part of the events, as recited by the officer, happened in a blind spot in the video. There is, however, video of the youth when at the point when he ran into the SUV, fell down, and then got up and ran back, tackled the officer, and the point where either the foot sweep or the kick, depending on whose version of events a jury were to believe, took place. An issue that would hamper the city here is that there was an investigation, and COPA concluded that the shooting was justified. However, that the kick, that what happened following the shooting was indeed a kick to the plaintiff, and that was excessive force, and accordingly, COPA recommended a 30-day suspension for that. That went up through command channel review and was approved. The officer has appealed that decision, and the appellate process is continuing. Plaintiff's initial demand in this case was $4,250,000. And this, again, is a federal case, which means attorney's fees, which we estimate would be well over $1 million if plaintiff were to prevail. Accordingly, we are recommending a settlement of $1,200,000 in this case as being in the city's best interest. Chairman?
Thank you, Jeff. Start out with Alderman Lopez.
Thank you, Chairman, and good morning, everyone. Before I comment on the case, I just want to ask Jeff, are we in the habit now of identifying which gangs people belong to? I think this is the first time I've heard you identify by name someone's gang affiliation.
It doesn't represent a new policy on my part. I think I've done it before. I stated it just as an attempt to provide as full a slate of background information as possible.
Okay. I just want to make sure that if that's the case moving forward, if we could ensure then either we're identifying everyone or we're identifying nobody. I personally don't like giving them airtime, but however you guys want to proceed, so be it. But that being said, I have a serious problem with this. The shooting was justified. This young man ran away from his home and was missing for several days. And now the parents are coming back. The father's coming back in the hopes of sticking it to taxpayers for the lifestyle his son chose. For the dangers that that child presented to the community, we're going to ask taxpayers to now pay the family for them having a child who was a identified and labeled gang member, shooting in the community, shooting at police, and unfortunately losing his life in a justified shooting with police officers. I don't think he warrants $1 million because he was kicked to subdue him. I don't think he warrants $1. He chose that path, and we should not continue to keep paying them. And I know, Jeff, what you'll say, that it's a judiciary issue, we're trying to save taxpayers money, but at some point, I'm going to say it, and keep saying it, and say it again, we have to stand up for the victims and our taxpayers and take them back to court. And if we're going to keep paying these settlements, then maybe put it in a fund so that the people that young man impacted negatively can get paid for their civil penalty, get it civilly from him for the damage he caused in the neighborhood. So, Chairman, I would ask that I be recorded as a no on this item and urge my colleagues to do the same. Thank you.
Thanks, Alderman. Let me go through a few other folks here first.
Excuse me, Chairman Wagasback.
Yes, go ahead, Jeff.
I just one point of clarification, which is even though COPA concluded that the shooting was justified, that is absolutely not a finding that would carry through and be binding on a jury. It is, in fact, a question whether that finding would even be, whether the judge would even allow that in, and thus a jury would, in all likelihood, be able to consider afresh the issue of whether the youth had in fact turned around or whether he had been shot while running away.
Alderman Lopez.
Thank you, Chairman. Thank you, Jeff. And I know we've had this conversation before, but it just makes my blood boil with the fact that our police officers are prejudged by Monell and other factors and rulings as automatically being at fault. And yet individuals are given a free pass despite having known documented histories of terrorizing communities because of their gang affiliations. At some point, I know it's not the purview of this committee, but at some point, judges and lawyers got to do better to make that case for the state.
Alderwoman Tavares.
I want to be recorded as a no.
Let me go to Alderman Napolitano.
Hold me as a no, please. Thank you, Chairman.
Alderman Thompson.
Chairman, it's Alderman Riley. Can we just do a roll call?
Yeah, but I was going to do that. I just thought that some people had comments first. So let me just state that we'll do a roll call first. But if I have several hands up, I just want to make sure that questions are answered first. So let me we will do a roll call and then go to Alderman Thompson first.
Thank you, Chair.
Thanks, Alderman.
Are there punitive damages in this case?
There certainly could be. This is a federal case. Plaintiff would be entitled to ask for punitive damages, and if a jury were to conclude that there had been a kick, that the officer had kicked a youth who was lying on the ground dying, that would put things into punitive damages territory.
But that wouldn't be determined until trial, or?
Correct. Victoria, do you have any elaboration on this, or the likelihood of punitive damages being sought in this kind of situation?
Punitive damages are at issue in this case. There is a claim against the officer here for it. Obviously, it's up to a jury to decide whether or not it's applicable, but there is a risk, certainly in any case, for that to be possible here.
Okay, and I'm sorry, this was the estimated cost to the city is more than $1 million and to put a trial on, did you say, Jeff? Or maybe it's Victoria, somebody can answer that.
The plaintiff's counsel in this case, we think, would assert over $1 million in attorney's fees alone if they were victorious. And as far as city fees to date, outside counsel fees to date are in the neighborhood of $300,000.
And what do we estimate that it would be for trial, Jeff?
We're estimating close to $80,000 to $100,000 additionally.
And the original ask again, I know we're talking 1.2 settlement, but what were they asking?
The original demand was $4.25 million.
Okay. Thank you.
Thanks, Alderman. Let me go to, I believe it was Alderman Cardenas. Alderman Cardenas.
Thank you, Chair. I guess are we looking at mitigating factors here also in such cases of suing the parents for negligence? Would that be a different, obviously, civil matter? But why not start initiating some of these cases, some of these proceedings, when it's pretty clear that something's afoul when some of these teens are committing some of these crimes? I think, for risk mitigation, the city should look at obviously paying now versus paying later. But there's got to be a different strategy. I mean, the city is on edge. People want accountability. And I wonder if we are polling this to the audience at large to see where we should go as a city. It is easy to settle sometimes because the risk factor on the other end is unknown. But under these circumstances, by crime on a daily basis in the city, I wonder if we're missing the mark in terms of, especially missing the outrage that a lot of citizens are having nowadays for having no accountability. So
Jeff, did you get most of that? George, you're breaking up.
I did. It sounded like an observation as to potential things to think about in the future.
George, I think we lost. Oh, there. Go ahead.
Sorry. So this is where sometimes it's tough for me, because I always look to mitigate risk for the city. Just how I'm built in terms of being accountable to the taxpayers. But I also wonder if we should be doing more as a broad, as a broad effort to also mitigate risks from other ways. And in the case of this kid, in the case of the parents who are accountable, for the city also to take a stand and send a message that you're also going to be held accountable, not just the city or police officers for doing their jobs in a very tough environment.
I would just note that I think taking an approach of suing the parents of a dead 14-year-old would be a fairly risky thing to do if it backfired in terms of public sentiment.
Okay, but are we gauging the sentiment of people now, or is it later? Are we polling to see where the population is at, where citizens at in these matters? I think from a financial standpoint, I get it, and I'm with you on that. But I think also we have to look at other factors to how to protect the city in a better way. Not simply suing, because that's what people do and that's what lawyers do on a daily basis, because they know at the end of the day, we're going to end up settling. They know that. I'm looking for something different. I don't know.
All right, Alderman.
Thank you. I know this.
Yeah, I'm not sure he can
right
answer that and on the
Right.
polling issue or anything like that, but let me go on to Alderman Sposato and then Burke. Alderman Burke.
Thank you, Chairman.
Alderman Sposato.
Thank you, Chairman. Jeff, how far was this away from his supposed home that he lived in, or his parents' house, or this incident?
Alderman, I don't know how far away from home he was. Victoria, do you have that information?
Good morning again, Victoria Benson. I don't have the exact distance in terms of how far away he lived. However, the shooting itself occurred in a ward different from where his parents resided and which would have been his home.
So, for all as we know, as he was terrorizing the neighborhood gangbanging at Cicero and Bernice. We don't necessarily know that he lived blocks away from there. We just know that's where the incident happened.
Correct.
And I'm happy to give you more information in terms of the addresses. I do have more specific information that I can give you. I just don't have the difference in terms of mileage. But this event did not happen in the same place that he lived.
Okay. Okay. That's kind of important information to me, but okay. Thank you, Chairman.
Thank you. Alderman Burke, ready?
Yes, can you hear me, Chairman?
Yes, we can.
Who's a plaintiff's counsel in this matter?
They are represented by Lane and Lane LLC.
And Jeff just mentioned that apparently the law department sought outside counsel that have been paid $300,000 to date. Is that correct?
That is correct.
And who is the outside counsel?
Vic, I don't have that in my notes. Do you?
Sure, I do. It's Victoria Benson. Borkin and Scahill represents the officer presently.
What's the name of the firm again?
Borkin, B-O-R-K-A-N, and Scahill, S-C-A-H-I-L-L.
And they've been paid $300,000 to date?
Close, yes.
Okay. Did you say, Jeff, that the decedent had fired shots at the police? I know I heard you say that he was armed with a .40 caliber pistol.
He did not. He did not fire any shots at police.
Okay. Chairman, I'm not going to vote yes for a $1 million kick. Put me down as a no.
Thanks, Alderman Burke. Jeff, who was the judge in this one again? You said it was a federal.
It's a federal case, and it's in front of Judge Jorge Alonso in the Northern District.
Jorge Alonso?
Yes.
Okay. And was there any work done by Judge Alonso to get to this settlement matter? Sorry, I got a fire truck in.
Let me wait a
Victor-
moment.
Victoria Benson, BENS1 again. No, we did, this was settled amongst the parties without court intervention.
Hold on, Victoria. Sorry, I can't hear you. 1 second. Could you repeat that? I'm sorry. I didn't hear you.
No, sure thing. No, this was settled between the parties without any mediation or court intervention.
Okay, thank you. Alderman Irvin?
Thank you, Mr. Chairman. 1.2 does seem to be a little high to me. But I will say this, these cases, we know, we understand the nature of having a police department, the nature of 1983 claims. I think that we may need to really take I won't call it a class, but some understanding of the liabilities that we face as a city and the liability that we face as having a police department. I've sat in on a magistrate case where they basically forced settlement in a lot of these cases and a lot of these matters. And I think while we may be making some moral statements, the reality is that we have to ultimately protect the taxpayers in these particular cases. Taking these cases to trial generally are losers. And then you're on the hook for thousands or hundreds of thousands, even millions of dollars in attorney fees. So I think we really need to, take a step back and not necessarily get into the emotion of this and deal with the rawness of that. If anything is found on the plaintiff's behalf, we're on the hook. And I know this is not what we want to hear, but this is the reality that we face being a municipality with a police department. So we need to focus our efforts on risk management practices, doing some different things so that we can reduce our exposure on these types of issues. So I understand that we don't like it. This is a bad sandwich, but unfortunately, being where we are, we have to deal with these matters. And if there's some other ways that we choose to handle it, let's talk about it. But, voting no just for politics is not helping us solve these problems. We need to really get to the root causes and put the mitigations in place so we're not continuing to have the same conversation.
Thank you.
Thank you, Mr. Chairman.
Thank you, Alderman Irvin. All right, are there any other questions from anyone?
Well, Chair, I think Alderman Jason Irvin makes a good point. This is Cardenas on that, and I'm always mitigating risk to taxpayers. But you as chair, then you need to call for a special meeting from you on practices that gets us to better answers.
Thanks. I'll take that under advisement. All right, we're going to do a roll call vote on this one. Give me 1 second. Get the paper there. All right. Oops. Hold on, Kamal. I think I've got a double mute thing here. Hold on 1 second. There we go. Okay. All right, ladies and gentlemen, this is going to be a roll call vote for
This is the second case.
Pedro Rios versus City of Chicago.
Pedro
This is
Rios.
item 1C, Pedro
Okay.
Rios. And all right, Chairman Wagasback votes aye. Vice Chair Hairston?
Aye.
Alderman Hopkins?
Aye.
Alderwoman Dowell?
Aye.
Alderwoman King?
Aye.
Alderman Sawyer?
Aye.
Alderman Mitchell?
Aye.
Alderwoman Harris?
Aye.
Alderman Beal?
Yep.
Alderwoman Sadlowski Garza?
Aye.
Alderman Thompson?
Aye.
Alderman Cardenas?
Aye, with conditions, as I
Yes.
mentioned.
Alderman Quinn?
No.
Thank you. Alderman Burke?
No.
Alderman Lopez?
No.
Alderman Moore?
Hey, Scott,
Yes. Is
add
this
me
Alderman
to the
Brookins?
roll and I'm an aye.
Okay,
Alderman
Alderman
Brookins.
Brookins, you're present for purposes of quorum and an aye. Let me go back to Alderman Curtis.
Madam President, yes.
Alderman Curtis, I couldn't hear you. I'm sorry.
Alderman Burnett is an aye.
Okay, Alderman O'Shea is not present. Alderwoman Tabaris.
No.
Thank you. Alderman Scott.
Aye.
Alderman Erb.
Alderman Curtis says no.
Thank you. Going back to Alderman Irvin.
Yeah, Alderman Irvin votes aye.
Thank you. Alderman Taliaferro. Order is not present. Alderwoman Austin.
Alderman Taliaferro votes aye.
Thank you.
Aye.
Okay, Alderman Austin, or Alderwoman Austin, I got you as an aye. Alderman Villegas. Alderwoman Mitz. Alderman Spizzato.
No.
Alderman Napolitano.
No.
Alderman Riley.
Alderman Riley votes no.
Alderwoman Smith.
No.
Alderman Tunney.
Aye. Aye for Tunney.
Alderman Osterman.
Aye.
Alderwoman Silverstein.
Aye for Silverstein.
Second. Chair, this is Vice Chair Hairston. I didn't hear you record my vote.
I had you as an aye.
Yes. Okay.
Sorry,
And
I'm just
Alderman
getting-
Burnett want to make sure you recorded his vote.
I did, yes. So I had 22 ayes, 9 nays. Unless someone else, let me just double check to make sure I got everyone there. Okay. Yes, so ladies and gentlemen, those in favor have voted 22 ayes. Those opposed are 9 or nays. In the opinion of the chair, the ayes have it and this motion carries by roll call vote. Thank you. Okay, 1 second, Jeff. All right. Ladies and gentlemen, moving on to our last item on the supplemental agenda. This is item 1D. This is a proposed order authorizing the Corporation Council to enter into and execute a settlement in the case of Anjanette Young versus the City of Chicago for the amount of $2.9 million. Here to speak on the settlement is Corporation Counsel Celia Meza.
Thank you, Chairman, and thank you, Aldermen, all that are present and committee members. I'm here to talk about the proposed settlement in Young versus City of Chicago.
Could you just introduce yourself for the record? Sorry, just to state.
I'm Celia Meza, Corporation Counsel for the City of Chicago. And I'm here to talk about Young versus City of Chicago et al. It's an overview of the case. As many are aware, the case arises as a direct result of the execution of a search warrant on February 21st of 2019 at the home of Anjanette Young by the Chicago Police Department. Ms. Young is an African-American woman who was 49 years old at the time of the events in 2019. The search warrant was based on incorrect information obtained from a confidential informant. The information provided by the confidential informant incorrectly identified Ms. Young's home as the home where a male lived and that he was in possession of an illegal firearm. The information proved to be incorrect as officers entered Ms. Young's home, who at the time lived alone and was employed as a social worker and had no firearms in her home. At the time of entry by CPD, Ms. Young was in a state of complete undress. Ms. Young was handcuffed upon entry of the officers while she was in that state of undress. And on that evening, a total of 13 officers entered her home during the execution of the warrant. 12 of those officers were male. Body-worn camera captured the events that took place within the home. And what is before this council is consideration of the settlement that was reached between the parties in this case from a state court lawsuit that was filed February 19th of 2021. That is the matter that is before you. This case was filed this year. Plaintiff initially filed a 6-count complaint, which alleged legal and negligence claims as well as emotional distress claims. And if this case were to proceed, I'll briefly go into to trial. I'll briefly go into the factual background. As is in all cases, there's a plaintiff's version of facts, and then there's the facts that the city would put forth in defense of this case. And the plaintiff's version would be that the officers on that evening failed to properly execute a search warrant and that they did not provide Ms. Young with a reasonable amount of time to respond to the knock on her door before entering her home, and that the officer's failure to properly knock and announce prohibited Ms. Young, who was in a state of complete undress, to properly cover herself. Plaintiffs would also allege that officers pointed guns at her and they handcuffed her with her hands behind her back, despite her being without clothing, and that officers ignored Ms. Young's repeated protests that they were in the wrong home. Plaintiff would also allege that they ignored Ms. Young's repeated questions asking why they were in the home, and that they left Ms. Young in a complete state of undress for an unreasonable amount of time, and the entire ordeal lasted over 40 minutes as the officers were in her home. If the case were to proceed to trial, the city's version of facts and defendants would be essentially they're similar, except there's key differences in terms of the execution of the warrant, and that is the city's position would be that the officers were at Ms. Young's home executing a valid legal search warrant, that the officers knocked and announced before entering the home. The city would put forth that the plaintiff stood in a state of complete undress for 16 seconds, at which time a jacket was placed around her shoulders for 13 seconds, after which time, 13 seconds after that, a blanket was put around Ms. Young. At any rate, it was not until approximately 10 minutes till she was escorted to her room to get fully dressed. The city's version of facts, of course, would be that the defendant officers were securing the area to ensure safety of all present. Importantly, the facts that are not dispute in this case are that the search warrant was obtained and the search warrant that was obtained was executed was a legally valid warrant, that the police executed that search warrant at the wrong home, that Ms. Young was in fact and is a law-abiding resident of Chicago who was in the privacy of her home in a state of undress when the police entered. It's not in dispute that she was handcuffed while in that state of complete undress. That she was left in a complete state of undress for 16 seconds after the officers entered, and that it took a full 10 minutes until she was allowed to get fully dressed after a female officer arrived and escorted her to her room. The city has never disputed that Ms. Young suffered an indignity on February 19th, 2019. And this settlement is presented to all of you in an attempt at this state to mitigate the potential risks of proceeding further in this case, and also to provide Ms. Young and the city of Chicago closure on the events that took place on February 19th of 2019. Now, in presenting this case to you, the city, of course, has done its assessment of the risks and matters if this were to proceed to trial. Importantly, when this lawsuit was filed in February, which is before this body, the city met its legal obligations by reviewing the complaint and reviewing to determine if there was any matters that were straight that could be dismissed on proper legal grounds before moving forward, so that the city could then properly assess what was left remaining if in fact the court ruled in its favor. So in September of 2021, the city didn't file a motion to dismiss. And in September, the state court granted the city's motion and dismissed 5 of the 6 counts. Importantly, the count that remained was what's called a willful and wanton conduct count. And at the time of that dismissal, the court granted the plaintiff the opportunity to file a second amended complaint. On October 22nd of 2021, the plaintiff and through her counsel did in fact file a second amended complaint, which left 2 counts, which filed it with 2 counts, count 1 being a willful and wanton conduct count against the city, and a willful and wanton conduct count against 12 individual officers. The claims that were rooted in law via the straight legal analysis, as I've discussed earlier, were in fact dismissed and were not repled. So importantly, the distinction that we're left here for the members of this body to consider is the willful and wanton conduct count. And willful and wanton briefly is regarded as an aggravated form of negligence. And in order to state a valid legal claim of willful and wanton conduct, the plaintiff must allege the same elements as negligence. They must allege that there was a standard of duty of care that was owed to the plaintiff. There was a breach of that duty, and that breach was a proximate cause of the plaintiff's injury, and that she sustained injuries because of that breach. Importantly, for all of you to consider is the count that is currently before you. Whether conduct is willful and wanton is ultimately a question of fact for the jury. So case law has determined that. So this claim is so broad, the willful and wanton claim is a broad claim. And what that does is it allows attorneys to take very broad discovery. Increased discovery, if this case were to continue, are increased costs to the city. That discovery is likely to include depositions of all officers, which would lead to costs to the city. Claim is also broad enough that it's unlikely that a court would dismiss, very unlikely the court would dismiss the case on summary judgment, meaning this case would in fact be left going to trial. A factor, proceeding to trial is not always, you may determine to go to trial, and that may be the appropriate assessment at any given time in any given case. However, in this particular case, COPA did a investigation, and their findings and recommendations, which were released to the public in November, would make it a little more difficult for the city to defend this case. And that would be because the very findings that they made against 5 of the officers, which included suspensions and up to 1 termination, in fact, would go to the very claim that was remaining, that willful and wanton conduct. What COPA found was that the 5 officers of whom they recommended discipline, that in sum, that there was a lack of due diligence in the investigation of the warrant. There was policy, there was a lack of appropriate policies, and there was a lack of trainings with regard to the execution of the search warrants, that there was a failure to properly knock and announce pursuant to policies, and that there was a failure on the part of some of the officers to activate their body-worn cameras. Again, because willful and wanton conduct has such a broad meaning, it's sufficiently, if we were to proceed to trial, a sufficiently outraged jury could award millions of dollars, even if there were a determination, and there would, in this instance, there would not be, that the police did not violate the Constitution or any law in obtaining and executing the search warrant. When determining an appropriate settlement, it's important to consider similar circumstances and other cases which were comparable to these types of factual patterns. And in this particular instance, the city looked to a prior, for lack of a better term, a bad warrant execution lawsuit. And again, there was a settlement that was appeared before all of you in 2014 and members of this body that were present, in which the city paid out $2.5 million. And in that case, it involved a case where a warrant was executed at the wrong home. And in that instance, a gun was unfortunately pointed at a 3-year-old in that case. In this case, of course, we have the indignities that Ms. Young suffered in the fact that she was in a state of undress for a total of approximately 16 seconds. And arguably before a jury, the 13 seconds where the jacket was put on and the 9.5 where she had a blanket over her, a jury could reasonably find that, or if some of you would be so inclined, a jury could unreasonably find that was 9.5 minutes too long. That was 16 seconds too long. And so when looking at those matters, similar cases that have proceeded to trial in reverse conviction cases, our juries are currently now, arguments are being made. If there's something to tie it to, in reverse conviction cases, for example, the arguments being made by plaintiff's case counsel are that there should be $1 million for every year that a plaintiff has spent in jail. In this particular instance, it is not unreasonable to assume that there would be a request for anywhere between 13 to 16 million, 13 million for every officer and the city that was involved in this execution of this warrant. Could be 16 million for the 16 seconds that she was left in a complete state of undress. What is left is whether a jury would determine whether it was willful and wanton conduct that the officers allowed Ms. Young to stay unclothed for a total of 16 seconds. And a jury could find that 1 second was too long, 2 seconds was too long, 3 seconds, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, of which she stood in a complete state of undress. The city made, from the period of time from January to the present, the city was making efforts to negotiate a settlement in this case, but at the same time, meeting its fiduciary obligations to dismiss the counts that did not have a proper legal standing. And the court, as I've indicated, agreed with that and dismissed 5 of those 6 counts, of the 6 counts of the initial, leaving right now the willful and wanton in a new complaint of 2 counts. So it is with that they come before you with the agreement that all parties have agreed to, Ms. Young and her counsel and the city, of $2.9 million. Thank you, Chairman.
Thank you, Corp Counsel Meza. Alderman Burke, would you like to start off with questions?
Yes, thank you, Chairman. Corporation Counsel, did the city retain outside counsel in this matter? And if so, what firm and how much has it been compensated so far, or how much are they expected to be paid?
Yes, we did, Alderman. So in this instance, as some may be aware, there was previously a federal court case which was handled internally by the city. But in this particular instance, when this state court case was filed, we retained outside counsel. Counsel representing the city was Eileen Letts from the law firm of Zubler and Lawler, and representing the 12 individual officers was Brian Gaynor. And I oversaw this lawsuit together with Ms. Letts personally and assisted.
How much have the outside counsel been paid to date, or are they expected to be paid?
Yes, so billed to date, Zubler, Lawler, at this juncture with the 2 motions to dismiss and answering of the complaint has billed a total of $46,000. And the individual officers, Brian Gaynor, was $25,773.
And I believe you said in your remarks that counsel for the plaintiff has agreed to this settlement.
Yes, Alderman. I have this morning received a fully executed document. So if this council were to agree, all parties have agreed.
Thank you.
Thank you, Alderman. Anything else there?
No, thank you.
Okay. Let me move on to Alderman Sposato.
Thank you, Chairman. Corp Counsel, I forgot to ask a question yesterday. So at the end of the said incident, whatever 45 minutes it lasted, at the very end, Sergeant Walensky was apologizing profusely. He offered his own personal cell phone. You could tell it was a very awkward situation by all involved, at least in my opinion. Does that have any weight in this case? Does that mean anything?
It certainly would be raised if we were proceeding to trial. We would point out that Sergeant Walensky, in fact, apologized after the fact, but a jury would review the instances that took place and determine whether that was sufficient. So that, again, that would be left to the jury. A jury could say it wasn't enough. A jury could say it was enough. Those are the risks that we face if we move forward.
Thank you.
Alderman Lopez.
Thank you, Chairman. Still good morning, members of the committee. Good morning. Ms. Mesa, how are you?
I'm good. thanks.
Forgive me for not being able to join the briefings yesterday, but at the risk of being called emotional, I just want to say that in my opinion, it feels as though this settlement is not enough. I think from where the lawyers and where Ms. Young originally started, from where we could expect to have been held liable versus to where the city made its first offer of $0, to be at less than 3, while good for taxpayers, in my opinion, I don't think necessarily does justice for Ms. Young. I understand that they have agreed to this. I understand that everything is signed finally and settlement can proceed after city council says yes, but my heart of heart tells me that this is insufficient. Unfortunately, for Ms. Young and fortunately for taxpayers, I'm not the one negotiating. If you say all sides are in agreement, I'm going to reluctantly support it. But I believe that we owed her more for the horrible way in which she was treated that day and in the re-victimization by this administration in constantly going after her when she did nothing wrong but being in her own home. It's not the first time, it won't be the last time, but I do hope, Corporation Counsel, that when these mistakes happen, that we use this as a reference point for how not to re-victimize people who've done nothing wrong but just sat in their own home, going about their own lives when that door comes breaking down. Thank you.
If I could clarify, thank you, Alderman Lopez. Just to be clear, as I indicated, you indicated that there was a $0. At the time of this lawsuit, when I became involved in this case, February 19th, 2021, at no time did anyone under my supervision and or I ever offer Ms. Young $0. The exact opposite. I have been engaged in active attempts to settle and negotiate. It is my understanding you are not incorrect, but I do want to correct something in the record, and that is that it's my understanding apparently at the time, the dollar that you're referring to happened in early 2019 after Keenan Salter, the attorney for Ms. Young, had already dismissed his federal lawsuit voluntarily. So there was no pending lawsuit against the city. And as is sometimes the case, when people offer to make amends or reach out, because the case had been voluntarily dismissed, it is my understanding that there was a junior attorney that did in fact respond and say there was no case, so there was $0. But I feel it's important for you to know that I wholeheartedly agree with you. Ms. Young needs to be compensated, and I was working diligently to do so, and at no time did I ever offer her $0.
Oh, Ms. Meza, if I may then, and I said the administration, I don't think I said you.
Oh, that's okay. I just wanted to make clear.
But because I do know that you came midway through, obviously. So we are well aware of all of that. But then let me ask you this, since this is your department, this is your wheelhouse that is coming up with the settlement. If you believe she's owed more, then why are we not giving her more?
No, I didn't say, I said at no time did I offer her $0. I believe, and Ms. Young and her attorney, Keenan Salter, all believe that based on the counts, it's a lawsuit, based on the legal counts that are remaining, that this is a fair and just settlement. And in a comparable type of case, what was reached in the settlement and what juries could potentially face. Again, it's legal analysis that is conducted by both myself and Ms. Young's attorney, where we would go in and the city would argue strongly that it was a valid search warrant and that there were factors that would support. Human nature are that there are errors and that they take place. So based on that, it's not a matter of what what it is a matter of what is a fair and just settlement based on the facts and the legal counts that we have standing. And it is that reason that we reached this amount and that her counsel were fully on board with it.
Okay.
Thank you.
Thank you, Chairman.
You're muted, Chairman.
Can't hear you, Chairman.
You're still muted.
Hang on, I think he's having a slight technical issue. Give us 1 second here.
How's that?
Now you're in.
Okay. Sorry, Alderman Napolitano. My apologies.
No worries. Thank you, Chairman. I just got two really quick questions. Based on this search warrant, what was, I know I've heard it before in some of the briefings prior to this too. What was the search warrant written for? What was the title? What were they looking for?
They were looking for an illegal firearm. A male who was in possession of an illegal firearm. A confidential informant advised that the individual lived at that home.
Okay, so that's considered a high-risk search warrant?
Yes, sir.
Okay, just for training purposes too, and separate from what Mrs. Young had gone through, which I can only imagine how bad that was. For training purposes going forward, is there an amount of time that we are going to be setting based off of this case that when we do a high-risk search warrant that an immediate all clear notice has to be claimed? And we're saying 13 seconds, or I'm sorry, 16 seconds until we attended to the victim, Miss Young, what she was going through. But was there an all clear or all safe call put out prior to her being covered up or attended to by the rest? Was the rest of the location thoroughly searched to make sure that said male offender wasn't in there with a firearm?
Well, Alderman, I think that's the point that I was making to you in terms of the facts in dispute. Obviously, the city's position on that would be that the officers, because it was a high-risk situation, needed to secure the area. But again, what was left remaining is, in fact, whether it is deemed willful and wanton conduct that leaving an individual standing there without clothes for a total of 16 seconds was necessary while 11 others or 12 others or 9 others secured the area. That is what we would be left with faced moving forward. In terms of your first question, I think it was a question in terms of whether there's changes have been made. What I can tell you is my understanding that the police department is in the process right now of amending the policy regarding execution of warrants, who will be present pursuant to the mayor's executive order, and things of that nature. So that is a work in progress and is working in conjunction with the changes that are also going on pertaining to the consent decree.
Okay, that's good to know. I appreciate it. And last question, going forward, based on that training module that'll be changed due to this case, will officers have the opportunity to elect not to be a part of a search warrant going forward?
That I don't know, Alderman. I'm sorry, I can't answer that.
All right, I appreciate it. Thank you so much for your time. Thank you, Chairman. Thank you for answering my questions.
Thank you, Alderman. Corp Counsel, just one question. What's the potential direct costs or maybe indirect cost of doing 12 depositions if we went that route?
It's extremely costly. And I wish I could give you a number, Alderman, but really it's going to depend because oftentimes the state court judges will give different leeways. Sometimes they'll limit them to 1 hour. Sometimes they'll say you can have up to 2 to 3. We're talking, there are 12 named officers. And at present at that would need to be outside counsel for the city, also counsel for the individual officers. So that is all additional costs and any additional witnesses, of course, that would be called in. It could be exponentially high in addition to where we're at, which is why we believe this is a reasonable amount.
Okay. So not just direct, I mean, it's a lot of indirect costs that we haven't.
That is correct.
Heard about. Okay. All right. Thank you for that. And thank you for coming in today. All right, ladies and gentlemen, are there any other questions for Corp Counsel Meza on this? This is obviously the Anjanette Young settlement. Anyone else have any questions?
Alderman Riley moves to pass.
Alderman Riley makes a motion to approve this item by affirmative vote of all members present for the roll call used to establish quorum. All in favor signify by saying aye.
Aye.
Anyone opposed? In the opinion of the chair, the ayes have it and the motion carries. And thank you everyone for being attentive to this item. Thank you Corporation Counsel Mesa and Jeff and Victoria for your assistance on these items. All right, ladies and gentlemen, there being no further business for the committee agenda today, may I have a motion to adjourn?
Mr. Chairman, Alderman Lopez.
Put me down as a yes if you missed the
Alderman
roll
Lo-
call.
Yes, thank you, Alderman Hopkins. I have you.
Thank
We
you.
just did a quorum call. Thank you.
Renew my motion.
Alderman Lopez, was that you, I believe? Correct? Yes.
Yes, sir. Motion to
Makes a motion to
adjourn.
adjourn. All those in favor signify by saying aye.
Aye.
All those opposed? In the opinion of the chairs, the ayes have it and motion carries. Thank you, everyone.